Welcome to our Encore Town Hall for Notaries Public, those who would like to be a notary and those who are interested. My name is Kathy Smith, and I am honored to be Maryland's Assistant Secretary of State. I provide executive oversight of the Charities and Legal Services Division. We're very proud of the 99.7% customer satisfaction rating our customers have rated our notary officers. Also with me today is our Division Administrator, Michael Schlein. We have notary officers and others from our staff in our division. Today's topic is, so you want to be a Maryland Notary Public? Please know that the platform restricts attendance, not the Office of the Secretary of State. In response to some emails that we've received, attendance at these town halls is not required. The town hall is also not the course of study, nor is it a substitute for the course of study that was required by the October 2021 law. Town hall is simply an outreach on our part to our notaries and those who are interested. We're thrilled you joined us. Today's town hall will address the requirements, the qualifications to become a notary, commissioning, enforcement, public information, the notary stamping device, journal, and allowable fees. Time is reserved at the end for questions, and you may find that your questions are answered as the presentation progresses. So you might want to hold off before you put those questions in there. You can also put questions in the chat box, but please refrain from answering questions in the chat box to prevent confusion about the source of information. Someone from our staff will announce the questions in the chat box at the end of the town hall, and we'll try to answer all the questions. Of course, we'll invite questions during that time as well. Today's PowerPoint presentation will be posted along with this recording on the Office of the Secretary of State website under the Notaries tab. Finally, the content and presentation provided is for informational purposes only. It is not intended to be legal advice. Let me repeat that. The content and presentation provided is for informational purposes only. It is not intended to be legal advice. As we begin, you are welcome to turn your cameras on if they work. We'd love to see your smiling faces, but please mute your microphones. Without further ado, please allow me to introduce our division administrator, my colleague, Michael Schlein. Mike?
Thanks, Kathy. Like Kathy said, I'm Michael Schlein, division administrator for the Charities and Legal Services Division of the Maryland Secretary of State's office. Our division handles many things, and the one thing that you are here today and interested in is Notaries Public. So you want to become a Maryland Notary Public. Today's presentation is specifically related to Notary Public and Notary Public information. A lot of feedback that we received on the last presentation or questions were asked about being a Maryland title insurance producer, commonly referred to as being a notary loan signing agent or a loan signing agent. Those are, in Maryland, it's called being a title insurance producer or title insurance producer independent contractor. That is regulated and administered by the Maryland Insurance Administration. It's a separate matter from being a notary public, and we will not be discussing those matters today. On today's agenda, for Notaries Public are the requirements, qualifications, commissioning, enforcement, public information, notary stamping device, the journal, and allowable fees. Sources of legal authority. So being a notary public, it's actually discussed in the state constitution as well as in the annotated code of Maryland, which is the state law, state government article Title 18, and in the Code of Maryland regulations, which is derived from that law. Requirements to qualify as a notary public. To become a notary, you have to apply, or to renew your commission, you have to renew online at this email address. At this website. Like Kathy had mentioned, the slides for this presentation are online. They'll be online, and you can get this link from those. So no need to hurry and write that down. Along with that application that you're going to file online, we need to have proof of residence. So a copy of your ID will be submitted along with any new or renewing application. what else might be needed to apply, what else is needed. You're going to have to complete the application, submit that driver's license or ID as part of that application, and there's a payment that is made. We'll talk more about the notary application and the information you need to have a little later on in this presentation.
Hey, Mike, it might be worth mentioning, as we talk about types of ID, that a passport is not acceptable because it does not bear the owner's address. And of course, having that address on the ID is what's really critical.
Correct. And when we're talking about the identification that's acceptable, we're talking about the identification that is acceptable to attach as part of your application. We're not talking about acceptable forms of ID that you can use when notarizing for an individual. So we want to draw that distinction as well. But correct, the identification used has to have an address. We're verifying address, date of birth, essentially that you are the person that you are who is applying, as best as we can determine that. Qualifications. So how do you qualify to be a notary? Who can qualify to be a notary? You have to be a person that's at least 18 years old, a person of good moral character and integrity, a resident of Maryland or employed in the state of Maryland or have a practice in the state of Maryland. So the old term in the law was living or working in this, live or work in the state. So this is a slightly reworded version of that. Be a resident of, or work, be employed, or have a place of practice in the state of Maryland. If living in Maryland, a resident of the senatorial district from which you're appointed, and if a resident of another state, not Maryland, then we'll allow that person that's working in the state to serve as a notary public. And when is this going to happen? How do you qualify to renew? 60 days before your expiration date, you'll receive a renewal reminder by email telling you it's time to renew your notary commission. And you can renew anywhere from 60 days prior to your expiration date up through 30 days after your expiration date. And that's the renewal window in which you can renew. The last requirement, the last qualification, is for an initial applicant. So if somebody filing a new notary application now has to complete a course of study and pass an examination offered by the Secretary of State or one of its authorized parties. And when renewing, must complete a course of study. So any new applicant's going to pass the course, pass the exam, and then they'll be qualified to apply to become a notary public. Any renewing notary applicant is going to have to complete that course of study prior to submitting that renewal application. And those are new requirements that went into effect October 1st, 2021.
Mike, it bears repeating again, I think, because we get so many questions about this. It seems to be confusing some of our notaries. So again, if you're a new notary applicant, you've never had a notary, or your commission has lapsed and you're applying again, you must take the course of study and the examination. If you're renewing your notary commission, you already have one, you're notary in good standing, and you're renewing your commission, you must take the course of study, but there is no exam requirement.
Correct. And you're right, that seems to trip some folks up, and thanks, and that did bear some repeating there. So commissioning, we talk about commissioning, notary commissions. What's a notary commission? Well, a notary public is an officer of the state of Maryland. So you're a public officer of the state of Maryland when you are appointed a notary. So a notary must take an oath of office at the clerk of the circuit court in the county in which they're authorized, or if in Baltimore City, to receive your commission prior to performing notarial acts. So if you are a resident of, say, Baltimore County, you would go to the clerk of the circuit court in Baltimore County to receive your notary commission, take your oath of office, so that you are then authorized to perform notarial acts. It is not until you take the oath of office and receive your notary commission at the clerk of the circuit court that you are officially a notary public. You're not authorized to perform notarial acts until you've taken that last step. So simply having an approved application does not make you a notary. Because you're an officer of the state of Maryland, you have to go take an oath of office at the clerk of the circuit court in the county in which you reside, or if you're an out-of-state resident but work in Maryland, ordinarily the county in which you work is where you go to take your oath of office. You have to take that step before you're a notary. So taking that oath of office and obtaining the commission, applicants are notified by email regarding the determination about their application. So if your application is approved, you're going to receive an email from our office that tells you how to appear before the clerk of the circuit court, how long you have to appear before the clerk of the circuit court, where that clerk of the circuit court that you're going to go is located, so that you can receive that commission. The notary must take an oath of office each time the commission is issued. So every 4 years, when you renew your notary commission, you'll have to go back to the clerk of the circuit court to take the oath of office for that next notary commission. It's not a one-time thing, and then you don't have to go after that. Every time you renew, you have to take the oath of office and receive.
Mike, I think this is a really good time to mention that, to underscore again, that the notary is a public officer.
Correct.
And often, we've heard stories about someone saying, go down to the clerk's office and pick up my commission. Will you please? The answer is no. Only the person being sworn in may go down to the clerk's office and be sworn in. No one else can substitute for them. And also, since you're a public officer, we'll talk in a little while about the notary stamp and the notary journal, and those go with the officer. If your employer paid for them, they are still yours. They are the responsibility of the notary officer. So please, undertaking this obligation and responsibility as a notary public is a serious, serious undertaking. So please make sure that you take this seriously, that you safeguard all of the materials that are entrusted to you, and you follow all the instructions so that we make sure that, we help you stay out of trouble.
Yep. And so going to the clerk of the court, it's an $11 fee to be sworn in. This is payable to the clerk of the court. It's unrelated to the notary application fee, payable to the clerk when you're there to take your oath of office. And a notary must be sworn in within 30 days of the issue date of this commission. Notice the underlined, bold, capital letters must be sworn in within 30 days. And within 30 days, the emphasis there, you're a public officer, you have to take an oath of office. When the Secretary of State's office issues your commission, you have 30 days to go there, take the oath of office, and receive your commission. If you do not, that commission is revoked. You have to make it there within the 30 days by law in order to qualify to become that notary public. We want to see you succeed. We don't want you to miss the 30 days. So really emphasizing that, pick it up within the 30 days. It's very important to do that. If you don't do that, that commission's revoked and you have to start over and reapply. Who wants to do that? Nobody wants to do that. We don't want you to do it either, right? We want you to get there and pick up that commission within 30 days. But if it doesn't happen, the law requires, it says it's revoked, and you would have to reapply at that point in time, start over. So we want to avoid that. We want you to avoid that as well. Issue date is the same date as the approval email. So if we send you an email saying you're approved today, that's the issue date. You have 30 days from today in that scenario to go pick up that commission from the clerk of the circuit court in the particular county where you'll be sworn in. So enforcement, can I have my commission revoked or suspended? Yes, it's possible to have that happen. A notary's commission can be revoked or suspended if a notary fails to follow the law, the regulations, or other requirements of being a notary public. If an investigation occurs because we receive a complaint, the secretary determines that there's cause to revoke a notary's commission, the notary will receive notification of the intent to remove them from office. The notary can contest that removal, can request a hearing held by the Secretary of State or their designee. These hearings with regards to contesting removal are informal hearings. Like, this is not, you're not going to court, so to speak. You're not in a courtroom with a judge and that type of thing. It's an informal hearing that you can request with the secretary or their designee to explain why it is you don't think you should be removed from office. Commissions can also be revoked if a notary fails to be sworn in by the clerk of the circuit court within 30 days of issuance. Mentioned it on the last slide, mentioning it again on this slide. Easy to lose track of time. We're all busy in life. There's always a lot going on. The days go by quickly, it seems, and we don't want you to miss out on the 30 days you have to be sworn in. So public information about notaries public. Will a notary public's information be published by the Secretary of State? Yes, there are certain information that's available on our website about a notary public. Applicant ID number, their name, the county in which the notary was commissioned, their expiration date, and their business phone number are all available from the notary search page on our website. Home addresses and phone numbers, they're not displayed on our website. There is the notary's work address is also public information, although we don't publish it on the website. It can be obtained upon request. If a notary does not provide a work phone number, a business phone number, and business address, or does not maintain a current work phone number or work address, then the notary's home address and home phone numbers are public information. A notary has to have a valid and current work address and work phone number for that to be the public information available about them. If that's not maintained, your home address and home phone number are the public info. And now they still won't be posted on the website, but they could be obtained should somebody request it if you don't have the work information.
And so that request comes through the Maryland Public Information Act request form. So it's not otherwise available, but when we are requested that information through that Maryland Public Information Act, we're obligated to provide it. And that's why we would prefer to provide a business address and number if that's provided. If it's not provided, then we have no alternative than to provide the information of record. If that happens to be the home address and home phone, that's what we're obligated to give.
Yeah, and will the Office of the Secretary of State publish a list of those authorized to perform remote notarizations? Yes, we do that, and it's you can find that link to the list on the notary page of our website, which will show you the notary landing page, the home page, a little later on. Just reviewing this this initial section here. To become a notary, you must be 18 years of age, live or work in the state of Maryland. Remember that notaries public are officers of the state of Maryland and must take an oath of office. A notary's commission can be revoked or suspended for failing to follow the laws or the regulations or other requirements. The notary's commission can be revoked if the notary fails to be sworn in by the clerk of the circuit court within 30 days of issuance. And there is certain information about a notary public that is available through the search page on our website for notaries. The next section here, we're going to talk about preparing to apply and processing time for notaries public. And there's the image on our notary page where you can click on that and manage your commission online. So before starting an application, a notary public is going to want to become familiar with and understand the Handbook for Maryland Notaries Public in its entirety. It's a big book. There's a lot to learn, but it's something you're going to want to and need to become familiar with. The requirement of the course of study now for renewing notaries will go a long way in that, because that's the content that's going to be covered. The handbook, the law, the regulations, any ethics, and all related to being a notary are going to be covered in that course of study now. So that's going to go a long way in helping notaries do that and understand what's going on. There are several notary resources listed here. Again, this is posted on our website already from last week's town hall, and we'll update that to reference this week's town hall as well. The Notary Division homepage, probably the best link you could have right there at the top. This is where you can find a link to the handbook. You can find link to FAQs. You can find the list of remote notaries. You can find a remote notary authorization form. You can find the list of course of study and education providers. That first page right there, the Notary Division homepage, is really the place you want to start off at. If you're looking for Maryland notary info, go to this page. The handbook can be found there. The ability to go, the link to apply or renew online can be found from this page. It's really your central hub for notary information. We also have links in there for the handbook, link to where you can look up the law itself, regulations, new notary application info, frequently asked questions. So know these links, use these links. They are good for notary information in Maryland.
Mike, it might just be worth mentioning, so that folks have a sense of the scope. When you said the Notary Handbook is a big document, it's a big book. It's about 50 pages. So that's a pretty large handbook, but if it's not a novel, okay?
Right.
So it's big enough that we want to make sure that you read it. It's very thorough, comprehensive. And so to Mike's point, before you begin the application process, make sure that you read the handbook, the law, the regulations, everything that he's got listed in here so that you're prepared to undergo the application process. Back to you, Mike.
Yeah, thank you. Yep. And as far as the application goes, it is time limited for security purposes, not time limited in the sense that you have a set amount of time to finish it, but time limited in the sense that if you are inactive for 30 minutes, it will log itself off and the information you submitted will be lost. You'll have to start over. So it's only if you've been inactive for 30 minutes. It's not a 30-minute limit to complete the application. It's if there's a period of 30 minutes of inactivity, you'll be logged off. So you want to have the information needed to fill out your application before you go on there, so you don't have to have a long period of inactivity and risk losing that information. What it is you'll need, we'll talk about on the next page. Other information you'll need: legislative district, where the applicant resides. So there's the website. You can look up your elected officials. Great to know who your elected officials are anyway, right? But you'll need to know your legislative district and your state senator for purposes of completing your notary application. You can look them up on that website just by punching in your address. So there's more information to gather for completing your application. If you're a new notary applicant, you're going to need to provide 3 references to attest to the applicant's character. And those references, we're going to need a name, address, phone number, and current email address for all 3 of the references. Can't just give us a name and an address, or a name and an email, or a name and a phone. We need to have all 4 of these data points for your references in order for your application to be considered complete. Digital image of the applicant's driver's license or valid government issued ID verifying the applicant's home address. You'll upload that. It's required that you upload that with the application. Mentioned earlier that a passport is not acceptable for ID on a notary application. Again, just speaking specific to the notary application, not identifying signers when you're acting as a notary. And why is that a passport not acceptable for a notary application? It doesn't contain your address. And we're looking to verify your name, that you live where you say you live, date of birth is the same, verify that you are who you say you are as best as one can on an application. If your driver's license no longer has your current address, say you got your license and you moved, you'll want to attach, in addition to your driver's license, your MVA change of address card that shows your updated address. I know there's a time frame on which you have to update your address with the MVA if you move. So you'll want to have that change of address card anyway, because that's your address of record. You'll want to attach that as well. If your ID on your application doesn't match that, which is on your driver's license, make sure that change of address card is there. To apply, there's also a $9 application fee, $2 service fee to do the notary application. Again, separate from the fee paid to the clerk of the circuit court when you're there to receive your commission. This fee here, we'll take it by credit card, electronic check, PayPal as methods of payment. For a new or renewing notary, a certificate of completion of the course of studies. We talked about new and renewing notaries now having to have to complete a course of study. You'll get a certificate of completion when that happens, and that'll be part of the application. You'll attach it just like you do your ID. And that course of study, a lot of people ask, well, when can I take it? I'm renewing. When can I take it? I renew, I renew 3 years from now. Can I take it today? No, don't take it today. You renew 3 years from now. You're going to want to take that course closer to your renewal, closer to your expiration date. And specifically within that renewal window that we talked about earlier, you're going to get an email from us 60 days before you expire that says you're going to expire. It's time to renew. You get that email. That's when you want to sign up and take the course of study. and complete that. The one that's available right now, and there'll be more added over time as more people submit and get approved. But the course of study that's online right now is one that can be done online and done on your own time. It's not so most people that have responded to us say somewhere between 2 and 3 hours to complete it, but really moving at your own pace through the information and through that course module that's available online. And then passing a certificate of passing the examination will also have to be uploaded for a new notary applicant. So again, course of study for renewing notaries, course of study and examination for a new notary applicant. And that examination is offered by the course of study provider. And it's an exam on the contents of that course of study that you took to learn about becoming and being a notary. So notary application, background determination process. What's happening when we get that notary application? You're going to complete that application online. We're going to receive it in our system the next business day. So if you were to go online now and complete the application, submit it, and send it in and make the payment, we'll receive that in our system tomorrow. And we'll begin the review process on that application. Going to run a background check. We're going to check the records, criminal record and civil judgments. We'll ask on the application itself, have you ever been convicted of a crime? If the answer is yes, answer yes. You must answer yes if the answer is yes, and you must disclose and explain what that was. Yes, I've been convicted of a crime. Here's what it was, and here's what happened. Same with civil judgment. If you had a civil judgment enter against you, what are we talking about with civil judgments? We're talking about non-criminal matters where maybe there's a dispute between two parties. It goes to court and a judgment is made in favor of one party over the other. Monetary is usually money is usually involved in those. If that civil judgment's been entered against you in the past, disclose yes, disclose it and explain. I can't emphasize enough. If the answer is yes, I've been convicted of a crime before, just answer yes. If you say no, you're going to find that out. And that's an easy way to get yourself denied because it goes back to the good moral character and integrity. If the answer is yes and you put no, that can get you into some trouble there. And the same with a civil judgment, right? Things happen. Be honest and open about it. Disclose it and explain it. Reference checks or review by state senator. This is on a new application only. References are not requested on a renewal application. So for a new notary application, if a senator opts out of the process to review those applications and they defer to us and our office reviews those applications, we're going to contact those references and we're going to contact them by email. That's the primary means of contact. We'll contact references by email. We get your application, we review it, and we'll send out a notification to your references by email to get a response, and so they can provide a reference for you as a character reference on your notary application. It's important that you give us a good email address for your references. It's important that your references know that they might be contacted about your notary application, whether it's an application that the Secretary of State handles because the state senator has delegated that authority to us, or even if the applicant senator participates in the process and makes the determinations, the senator is going to contact those references and make a determination. So you want to have up-to-date reference info. Your references should know they might get contacted about your notary application. And that way they know, they receive it, they respond to it, and they respond to it in a timely manner. And that way it doesn't hold up the process any. So make sure the reference info is good contact info. Make sure the reference knows it is coming. A determination, if approved, the commission is issued by the clerk to the clerk of the circuit court. We talked about commissioning earlier on, that it goes to the clerk of the circuit court in the county in which you reside. If you're a Maryland-based notary, if you live in Maryland, if you live out of state, it's going to get issued to the county in which you work. Some folks, maybe they do work in multiple counties, they live out of state but work in multiple counties, we'll select one, and usually the most convenient or most worked in county is where it'll get designated and you'll get sworn in at. So if approved, it's going to go to the clerk of the court, and if denied, the applicant's going to be notified of that denial.
Mike, if I could just add, for both the applicant and the references, please ask your references to check their spam folder, so that if indeed they receive the reference but doesn't come right through, it could get caught in the spam folder. And do that yourselves when receiving the response regarding the determination of your application status. Check the spam folders, please. We don't want anything delayed, but of course, spam is doing its job when they see unfamiliar emails sometimes. Back to you, Mike.
Yeah, so timeline to process an application. If the senator opts out and delegates authority to us for the review and of their applications in their district, it's usually 2 to 3 business days for determination to be made, whether that's a new or a renewing application. Doesn't take long. The only times it really takes longer than 2 to 3 days to review an application by the Secretary of State's office is if the references don't respond to the new application. That's really the number one reason or the number one holdup on a new application. And really for new and renewal applications, the other big delay occurs when somebody submits an application and it contains missing, there's missing information or a partial answer, or there's something wrong with the identification that was attached where it doesn't verify a home address. When that happens and we receive an incomplete or somehow incorrect application, we're going to send an email to the Notary Public letting them know it's incomplete and what we need to get that application completed and moving forward. So submitting the application, great. But there are some pitfalls in which it can get held up. Biggest ones are references or missing or incomplete application information where we've contacted the notary and just do not receive a response. If the senator reviews a notary application, so a new notary application where the senator still maintains that authority to review it and hasn't delegated it to us, it's really up to the senator's office. They decide when to make the determination, and it's entirely up to the state senator's office to decide when and how to make that determination. And you can check your status of your notary application on the same place where you apply by going to that link and clicking check status of a submitted application. Be proactive. If you're in a district where the Secretary of State does the review of the application, 2 to 3 days is really all it should take. If you haven't heard anything in a week or two, you want to check back in and make sure all is okay. Never assume, in terms of an application that we have it and it'll just get done whenever. It really doesn't take very long, especially if our office is the one making the review and the determination. And even if it's a senator's office reviewing it, that, one that doesn't opt out of the process, if you haven't heard anything in a couple of weeks, check in with us. Make sure we haven't either. The last thing you want to do is assume it's being worked on and not check in. Months go by and you think about it, you go, oh, let me check in, come to find out we've approved it, sent you an email, and it just, maybe you didn't see it, maybe it got stuck in your spam folder and it was missed. You want to be proactive and follow up. If you don't see that approval email or an email from us asking for more information or something, you want to follow up and check. Don't let it sit. Don't let it sit for a long time, because what you risk having happen in that situation is the email is sent saying your commission's approved, go to the courthouse in 30 days and get sworn in. And then all of a sudden you missed that 30 days, didn't even realize you had it, maybe even, but you missed it, and then you have to reapply because it's been more than 30 days and that commission was revoked. So proactive, check in, monitor. Don't let it sit for a long time. Again, all the idea of we want to see you succeed, right? We want you to get it within the 30 days. We don't want you to miss the notification that it was issued and approved. We want you to see it, make it to the courthouse, and become that notary public. Reviewing here, gather required documents before beginning the application. read and become familiar with the law and the handbook, the regs, all that information before becoming a notary. Again, the course of study is going to help significantly with that. Applicants are automatically logged out of the system if they're inactive for 30 minutes. That information is lost. Applicants must disclose if they've been convicted of a crime. They must disclose if they had a civil judgment entered against them. Family members and employers may not be used as one of the three references. Photo ID must contain an applicant's address for the purpose of completing the notary application. We're trying to verify your home address on the application, that you are who you say you are and you live where you say you live. Notary public must be sworn in within 30 days after the commission is issued. Can't emphasize that enough. And there's an $11 fee charged by the clerk of the court that's unrelated to that application fee. You're going to pay the application fee to us at the Secretary of State's office. You're going to pay the fee to get sworn in, take the oath of office, and pick up your commission to the clerk of the court. So next section here, we're going to start talking about the notary stamping device, journal, and allowable fees. Notary stamping device, oftentimes better known as the Notary Seal. In the old law, it was called a Notary Seal. In the new law that took effect October 1st of 2020, it's referred to as the notary stamping device. You'll use both terms interchangeably. So notary has to purchase their own seal at their own expense. That stamping device or notary seal, it is a public seal. As a notary public, you're an officer of the state. Therefore, it's a public seal, and it is your seal. Doesn't matter who purchased it. If you purchased it, if maybe your employer purchases it for you, if they purchase it for you, it is still your seal. It has your name on it, right? It's your name. You, the individual, are the notary public, not the company. You are. It's your seal. It's your property. It's not the employer's property. Even if you were to leave that employer who may have paid for your seal, it is yours and you must take it with you. It is not theirs. The notary is responsible for the security of their stamping device. Never, 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 ever, ever, never, ever allow another individual to use your stamping device, to use your notary seal. It is yours. It has your name on it, and it is only yours and only to be used by you. So notary stamping device must be capable of being copied with the record to which it is affixed or attached or logically associated. It must be an embosser. It must have raised impression on the paper, or it could be a rubber stamp with the ink impression. Both are acceptable. Both are used in Maryland. If that stamping device is lost or stolen, promptly notify us. Tell us when you discover it's missing or that it's stolen. Let us know. Remember, it's your property. You're responsible for its security. If it gets lost or stolen, notify us so that we can be aware of it. We want to know if it was missing so we know, we can keep an eye out for that. What if it starts showing up on things that you didn't do, right? We have a record of you letting us know that it was lost or stolen. So be proactive on that and tell us. If the commission, if your notary commission, you resign, you get revoked, it just expires. You decide, I don't want to renew, it's just going to expire. The time your commission is over, you must disable the stamping device. And, if it's an ink stamper, the rubber stamp, it's pretty easy, right? Take the rubber piece off and cut it and make it so that it can't be put back together, throw it in the trash, done, right? The embosser is a little harder to render unusable. You might have to disassemble it in order to make it unusable or scratch it up or mark it up or otherwise damage it. But you want to make sure nobody else can use that when you're done with it. Remember, it has your name on it. You're the notary, and it's your seal, your property. So imprint on the notary stamping device. The notary stamping device must contain 3 items. 3 items are required. The notary's name as it appears on the commission. So my name's Michael Schlein. If I'm commissioned under the name Michael Schlein, that's the name that should appear on my commission. If my middle name is John and I want to use my full middle name, it should be Michael John Schlein. If that's my name on my commission, that's the name that appears on my seal. It could be Michael J. Schlein. Point is, whatever the name on your commission is, that's the name that needs to appear on your notary seal in that form. The other item, the second item, is the words Notary Public. And the third item is the county in which the notary resides. So if you are a Maryland resident, you live in the state of Maryland, your notary seal is going to have the county in which you reside. So say I reside in Baltimore County, my notary seal would say Michael Schlein, Notary Public, Baltimore County. And if you're an out-of-state resident, you're going to qualify and get sworn in at a clerk of the circuit court in whatever county that ends up being, most likely the one in which you work. And your seal will say the county in which you were qualified as well. So whatever county in which you get sworn in and receive your commission, that's the name of the county, or if it's Baltimore City of Baltimore, that needs to appear on your notary seal. This next line, I'll read it. Don't panic. After I'm done reading it, effective October 1st, 2020, the notary seal will be required to contain the notary's expiration date. That is, unless the notary's expiration date appears in the notarial certificate. Well, also effective October 1st, 2020, every notarial act must contain a notarial certificate. There has to be a notarial certificate on every notarial act now. And our law gives examples of notarial certificates, and every one of them, that certificate contains a place for the notary's expiration date. So if you're notarizing today correctly and using the notarial certificates that contain a line where the notary can write their expiration date, then you don't need to worry about getting an expiration date on your seal, because it's going to be a part of the notarial certificate. So you really do need only those three items. Some folks will ask us, can mine say state of Maryland? Sure, it can. If you want to add state of Maryland to this list of things, great, go ahead. It can say Michael Schlein, Notary Public, Baltimore County, state of Maryland. That's fine. It doesn't have to say state of Maryland. It can say state of Maryland, but it has to say these three things: name, Notary Public, and county of commission. Notary Journal. So a notary is required by law to maintain a journal. In the old law, we knew this by the Fair Register of Official Acts, or your register. Journal, important. It logs the notarial acts that you have conducted, performed, into a record. That journal must chronicle all notarial acts performed by a notary public. All of them, every one of them. Lots of people will say, well, they're my friend. Still has to go in the journal. I didn't charge them for it. Still has to go in the journal. Whether you know them, don't know them, whether you charge them for the notarial act, didn't charge them for the notarial act, every notarial act must be chronicled in the journal. If a notary notarizes for the same people regularly, still have to enter each individual notarial act into that journal. Has to be done, every act, always. Entries in a journal shall be made contemporaneously with the performance of each notarial act. So in the same occurrence as that act, if you notarize now, can't wait till later tonight or tomorrow to make your journal entry. It has to be made contemporaneously with the performance of your notarial act, to the same time or setting. And the notary shall retain the journal for 10 years after the performance of the last notarial act.
And Mike, it's really interesting to note that for those folks who have said, well, I notarize at work, so I've got a journal there, and I also notarize at home, so I've got a journal there. What I'm hearing you say is that you need to have one journal that is in chronological order, that contains all of the journal entries for every single notarial act. So you would actually move that journal from work to home and from home to work. If you are notarizing in both places, it is not acceptable to have two separate journals.
Yes. Yep. And we're going to talk about in a couple slides. We're going to go over scenarios for the paper journals, the book journals, the handwritten ones that most notaries are familiar with, and electronic records. Slightly different rules and requirements for a traditional paper journal versus an electronic one. But the point there is, for most notaries who are going to use that book form journal, you can only have one, and it needs to contain all of your notarial acts. what does a record in a journal have? Each journal entry should have the following items: the date and time the notarial act was performed, a description of the record, if any, and the type of notarial act that was performed, the full name and address of each individual for whom the notarial act is performed. So name and address of everybody that's coming before you to get a notarial act done by you. If the identity of the individual is based on personal knowledge, a statement to that effect. So what does that mean? I know you. Assistant Secretary Smith and I know each other. We work together. I know her. She knows me. I have personal knowledge of her. I know she is who she says she is. I know her. I know her. I don't just happen to sort of know the person or know them as an acquaintance or I'm familiar with them. Personal knowledge. I know that person. I know they are who they say they are. I know them. If the identity of the individual is based on satisfactory evidence, a brief description of the method of the identification used, the credential presented, including the date of issuance and expiration of any ID and the ID number associated with that ID credential. So, fancy way of saying your driver's license number, you're on your driver's license. So, I don't know you. I have to identify you to verify you are who you say you are. You show me your driver's license. On that driver's license, there's an issue and expiration date. There's a driver's license number. You log that information into your journal. And you also give a description of the ID. So say it's a Maryland driver's license, you would note Maryland driver's license, issue, expiration, driver's license number. Say maybe it's a driver's license, somebody that lives out of state that happens to be in Maryland at the time and they need you to notarize something. Maybe it's a Virginia driver's license. Your Virginia license number, whatever their number is, issue, expiration. The point is you want to log in that you use somebody's ID, what kind of ID it was, and these details on that ID for each person that you identify that way. You also have to note the fee that you charge, if any, by the notary. If no fees charged, the record should indicate that. We'll talk about fees here in short order and what fees are allowed. Indicate whether an individual making a statement or executing a signature, which is the subject of the Notarial Act, in the notary's physical presence or remotely by means of communication technology. What does that mean? If you're doing a traditional notarization in person, you watch the person sign the sheet of paper, you notarize their signature and affix your info to the sheet of paper. That's a notarization done in one's physical presence. There's something now called remote notarizations, remote notarial acts. We'll have a whole different town hall about that subject in the future. But if you perform a remote notarial act, your journal entry should indicate that it was done remotely using communication technology. So Kathy mentioned a couple of slides ago. Here we are right on this Notary Journal page, right? You must have a journal. If you have a journal on a tangible medium or an electronic medium, you have to have a journal. So what's a tangible medium? Just on paper in book form. Electronic is exactly what it sounds like, right? An electronic record. The notary shall maintain only one journal to chronicle all notarial acts performed regarding tangible records. So your traditional notarial acts, your traditional notarizations done on pen and paper, done with pen and paper, in person, in front of you, live in the same room, watching them sign after you identify that they are who they say they are, and then you notarize the document, you make your journal entry simultaneous with that act. Only one journal for all of those acts. Can't have multiples, can't have one at work and one at home. Have to maintain only one journal for all notarial acts regarding tangible records. If you do electronic notarizations, you may have one or more journals to chronicle those notarial acts performed regarding electronic records. Why people might, well, why is it different for electronic? Well, if you're doing remote notarizations, you're authorized to perform remote notarial acts. You'll know that there's a bunch of technologies, companies whose technology is allowed to be used for remote notarial acts in the state of Maryland. And those platforms are generally going to come with an electronic record that that journals all the transactions performed on that platform. So you may have 2 or 3 or more technologies that you use or subscribe to perform those remote notarial acts. And for those acts, you're going to use the journal that's on the platform of the provider you're using at that point in time. So you may have more than one provider, and that's okay. For traditional notarial acts, one journal, that's it. For remote, you may have more than one. Tangible medium journals, they must be permanent, bound, registered with number of pages. Why? Well, your journal needs to be a journal, right? You keep it, it's one book. You enter things chronologically as they occur. And if it's permanent, bound with number of pages, that ensures we're moving chronologically. You can't just write stuff on paper and shuffle it in and out. The old law really talked about keeping a register, but didn't really tell you what to keep, how long to keep it, and what form it should be. This law provides a lot more detail and better information about what is required for each journal entry, how long you need to keep it, and the manner in which your journal should be kept. So tangible journal, a paper journal, permanent, bound, registered with numbered pages. If you keep an electronic journal, must be in a permanent, tamper-evident electronic format that complies with the law and any regulations adopted by the Secretary of State. If you're using the journal on one of the remote notary technology platforms, they comply with the law and any regulations. That's why they are an authorized RON vendor. Allowable fees. I'm going to break this down a little further after we go through it. This is one of our other main sources of questions from folks on a regular basis. A notary public may demand and receive up to $4 for the performance of an original notarial act. This is the fee charged for each signature that a notary notarizes. So I'm notarizing your signature, right? I'm notarizing that you signed this document or that you acknowledge this document as your act and deed, or I'm notarizing that you've sworn that the contents of this document are true or true to the best of your ability. For each time I do that, that's a notarial act. That's $4. If multiple people are signing this document and multiple people need that signature notarized, it's $4 per signature. So if there's 2 people who are signing and having their signature notarized, 4 plus 4 is 8. So 2 people 8, 3 people 12, and so on. $4 per notarial act. Additional copies of the same document, the notary may receive $1 for each notarized signature. So if I bring 2 of the exact same thing to somebody to ask them to notarize it, they notarize the first one, $4 per notarial act on that first one, and the exact same thing a second time is $1 per notarial act on that second one. A notary may not demand and may not receive more than $1 for each photocopy made of a notarial act if they're asked to make a copy of the notarial act. And when we're talking about making a photocopy of the notarial act, we're talking about the notarial act itself. We get, what if the document's several pages long? Well, if you're being requested to, the law is only addressing the fee for copying the notarial act. So that 1 or 2 pages where the notarial act or notarial acts appear, that's the $1 for each photocopy that you're charging. Notary may also demand and receive reimbursement at the prevailing rate for mileage as established by the IRS for business travel. That IRS mileage rate is often posted. It's posted on our website, but really the best place to check is the IRS, and the IRS updates that as it changes. It usually changes once a year at the beginning of the year, and so you want to use the prevailing rate for business travel as established by the IRS for your mileage reimbursement. But by mileage, we're referring to round trip mileage. If you go somewhere, you still have to return, right? So you can charge mileage for your total trip, not just one-way mileage. A notary public may demand and receive reimbursement for a fee not to exceed $5 for travel if required for the performance of a notarial act. So you have to travel, you can also charge a $5 fee. Breaking this down a little further, let's use a scenario where I have to travel for a notarial act. What can I charge? Well, if I have to travel, I can charge $5 because I have to travel. On top of that $5, I can also charge the mileage rate. So X miles at X rate, round trip. And I can also charge $4 per notarial act. So again, if I'm traveling, $5 because I'm traveling, plus mileage, plus $4 per notarial act. So that's what you can charge. And that's all that. These are your allowable fees. Folks ask us all the time, well, can I charge a convenience fee? No. Can I charge because they asked me to travel to them late in the night? No. It is what it is with these fees, right? No more than $4 per notarial act, no more than the mileage rate for travel, no more than a $5 base fee for travel. So $5 to travel plus mileage plus $4. There's no convenience fees. There's no tips. A frequently asked question that we get is, well, what if somebody, they try to pay me $5 and they just tell me to keep it? Well, the law says you may demand and receive up to $4. So you can't demand more than $4. You cannot receive more than $4. Got to make the change. So,
and just to say that the law does not require that you charge a fee. The law just requires if you charge a fee, it cannot exceed the fees that Mike just identified. Also, because you may have more than one fee for one act, as Mike just said, you could have the $4 fee for the notarial act, you could have a $5 travel fee, $1 for digital signature. It's really wise to itemize those in your journal so that if you're questioned at another time, the sum total of that fee doesn't appear to be the charge you charged for the notarial act. And that's really critical because if there's a complaint lodged against you at a later date, you will then have documented what that charge is, what the breakdown is, and that in fact you only charge the allowable $4 fee and other fees.
Great point, Kathy. Great point. Yeah, you've already done the math to come up with your total. Why not itemize that math in that record in your journal so you know why you charged, what you charged, and done this long enough to know that we get complaints, and later on down the road, if there's a complaint about how much you charged, the person making a complaint may only say, well, they charged me this. They may not even know or care to remember that it was because you traveled to them and there was a mileage fee. And so when you do make them, like Kathy said, do the math in the book to itemize that. You've already done it anyway. Why not note it in the book? Never a question. It's there for when you come back to it later if you ever have to. Hopefully you never do, but you might. And you want to have that record there. Great point on itemizing that in the journal. You already have to record the fee in the journal. May as well say what it is. And yeah, again, reviewing this section, the Office of the Secretary of State does not provide notaries their seal. They must purchase it on their own. If they leave their employer, they should take it with them. The notary seal must have those three items: name, the words Notary Public, and the county, or if Baltimore City, in which the notary was appointed. The journal must contain a record of every notarial act, even if the notary knows the person signing the document, even if you didn't charge a fee, even if they're your best friend, doesn't matter. Always make the journal entry. It is required for every notarial act. And the law establishes that the fee a notary can charge is a maximum of $4 for each notarial act. That is all you can charge your customer for the notarial act. We talked on the prior page about traveling and fees for travel and a few other fees. There are no fees outside the ones we just discussed that a notary can charge for notary work. Folks sometimes will ask about, mentioned earlier, title insurance producing. That's not our agency. We do not do that. But there are fees sometimes that someone can charge as a title insurance producer, and that is for their job as a title insurance producer. It is not related to any fee being charged for a notarial act. So just to try to get ahead of any of those questions, we're talking specifically notary fees for notarial acts. We're not talking about work that somebody may do as a title insurance producer that is licensed to do that work.
Yeah, and those
So-
questions should be directed to the Maryland Insurance Administration, just like any questions regarding real estate transactions should be directed to the Maryland Real Estate Commission. So they are beyond our scope of authority and our statutory and regulatory scope of authority.
Right. Yep. We can't tell you the rules and the law on those items. It's best to always talk to the agency that regulates that to get that information. Kathy?
Yep, thanks, Mike. So we have some upcoming town hall meetings, as we've talked about earlier. On March 28th, we'll have a brief overview of the Notary Handbook, the laws and regulations. On May 23rd, the types of notarizations, the allowable actions a notary may perform. September 26th, how to avoid complaints, the top 10 mistakes. And Mike talked a few times about remote online notarizations, sometimes called RON. And on November 21st, we're going to talk about remote notarizations. Each of these upcoming town halls have a lot of information, a lot of content. We encourage you to attend if you are so inclined. Always remember, please, that these town halls, today's and all of them, are intended to be informational only. They are not intended to be legal advice. The PowerPoint from today's slide and this recording will be posted on the Office of the Secretary of State's website, which is on an upcoming slide. And Mike, just to talk for a second, we've had a few questions throughout the town halls that we've had. One of them continues to be about the course of study and examination. So just to make that point again, the course of study is required for every single notary who is applying to be a notary public. Every single applicant must take that course of study, and they must also take the examination. Every incumbent notary, that is a notary who is up for renewal, must take the course of study. They are not required to take the examination. Let me repeat that. Every renewing notary must take the course of study. They are not required to take the examination. So just to know about that. Another question asked is, what is the fee? The fee is determined by the test provider. The Office of the Secretary of State does not provide that. Another question asked was, is this the same course of study that you had on the website last year? Now, we had a webinar on the website last year as a courtesy, as this is, and as some information. The course of study is actually an actual course of study provided by an education provider, and they are the ones who issue all of the materials to you that you need in order to succeed in that course of study. They administer the examination. They provide the certificate that you actually attended, and they provide the certificate that you passed the examination. No, the Office of the Secretary of State is not going to be administering these course of study nor the examination. They are done by independent providers. Mike, were there other questions that you wanted to address?
Yeah, some other questions that we receive throughout these presentations. One of them was regarding the how soon can I take the class when I renew? And we mentioned a little earlier, you're going to take that within your renewal window, right? You get 60 days before you renew. You're going to get an email from our office that says it's time to renew. You're going to expire in 60 days. At that point in time, you'll want to take that course of study. You can take it anywhere within that renewal period. Another question that comes up comes up frequently is another one you mentioned a little earlier as well, which is that I don't expire for 3 years. Do I need to take that class? I already renewed last year. Do I need to take the class now? No, you take it when the next time you renew is when you'll complete that course of study. Do not have to take the course. If you're currently commissioned, you'll take it the next time you renew. The law went into effect October 1st of 2021 for the course of study, and for new applicants, the course and the exam. So if you were renewed or applied and were approved prior to October 1st, you were not required to complete the course at that point in time. You'll be required to complete it the next time you renew. A lot of title insurance producer questions as well. Again, just re-emphasizing that anything regarding notary loan signing agents, which is kind of the common term used, which are really title insurance producers, make sure you contact the Maryland Insurance Administration with questions specific to title insurance producer law or licensing requirements. Again, this is not that. This is just for notaries public. And those are the frequently asked questions that we have. We get some questions about the journal. What if I was keeping 2 journals rather than 1? If you've been keeping 2 journals rather than 1, stop now. Now's that time to stop, right? Use 1 journal, keep your other one, right? You need to keep that record for 10 years, but start using 1 journal. Don't use both of them anymore. Use 1 moving forward and keep your other record for at least 10 years. Keep it safely, keep it securely. Folks also reach out some questions about what happens if my journal is damaged, maybe my house flooded. Let us know, right? Let us know. Report to us if your seal is lost or stolen. Report to us if your journal is lost or stolen or damaged. Let us know that that is the case so that we are aware of that. And I think you've said it best before, Kathy, where it's, this is an important record, right? Keep it in a place that reflects that. Don't leave it on the basement floor, so to speak. Put it in a place, use a filing cabinet, a desk, somewhere that's in your control and possession, and store those records securely for at least 10 years. And the other question that comes up related to that is, what happens if somebody passes away that's a notary public? Who's responsible for keeping that journal for 10 years? And the person that's responsible for their estate is the person that will assume control of that notary journal and maintain it for that length of time that's required.
Thanks, Mike. I guess in short, being a notary is public officer. You're the one who gets sworn in. You're the one responsible for securing the seal and the journal. Even if your employer purchases the seal and purchases the journal for you, if you leave that employment, you take the seal and the journal with you. You're the one commissioned. Commissioning is assigned to the individual, not to the company. So I think those are the highlights of the questions that we've had so far. We're so thrilled that you joined us today. Please stay tuned for future town halls. We look forward to hearing from you, and we look forward to being in touch. Thanks again, Mike. Thanks so much for the great job you do today and every single day. Have a great day, everybody. Be safe. Take care. Bye-bye now.